Welcome everyone to the Adams and Reed's HR Summit. We're here to talk to you today about Supreme Court decisions that came out this recent term and their impact on your businesses. For those who don't know me, my name is Lauren Tafaro. I'm out of the New Orleans office and I practice employment law. With me is...
I'm Hunter Schoen and I'm in the commercial litigation group and also practice employment law.
The four cases that we'll talk to you today about are Bostock versus Clayton County,
Our Lady of Guadeloupe,
Babb versus Wilke,
and Intel Corp versus Sulyma.
The first is Bostock versus Clayton County. It's a monumental decision out of the Supreme Court this past summer. The vote was 6-3 between the justices, and it involved actually three separate cases that were subsequently consolidated into one. They all involved the same legal issue. The first case involved a gay county employee who had worked for the county for several years and disclosed that he was gay by playing in a gay recreational softball league. Shortly after he participated in the league, he was terminated. The second case involved a skydiving instructor who was also gay, and to put female clients at ease because he was going to be strapped to the top of them, he disclosed that he was gay, and then shortly thereafter he was terminated. The third involved an employee who was hired as a male, who was assigned to be a male at birth, and throughout his employment he then decided to change to being a female and to transition into being a female. He disclosed to his employer that he would be taking leave to have a sex reassignment surgery, and that once he returned he would be a female, and shortly thereafter she was terminated. All three cases, the terminations at issue were not disputed. All three were terminations because of sexual orientation and gender identity. All three plaintiffs filed suit under Title VII, which Title VII, as we all know, protects or prohibits discrimination for certain protected characteristics, one of which is because of sex. And so the court was faced with the issue of, does discrimination based on sex encompass gender identity and sexual orientation? The court went through a very detailed analysis about the causation and what causation standard applied. It ultimately said the but-for causation standard applies to this type of situation, and if the decision was in any way based on sex, then it was a violation of Title VII. So if you take sex out of the decision-making process, then, and the decision would have not changed, then it would not be a violation. So the court looked at, if sex was not considered, would a different result have been reached? And the majority said that discrimination based on sexual orientation and gender identity is discrimination based on sex. The court specifically said it's impossible to discriminate against someone for being homosexual or transgender without discriminating against that individual based on sex. And the court gave a very detailed analysis and a specific example that says, assume you have two employees, both of whom are attracted to men. One employee is a female and the other is a male. And if you terminate that male simply because he's attracted to another male, but you don't terminate the female, that is absolutely based on sex, because you're allowing a female to engage in conduct which you're not allowing a male to engage into, and that's discrimination. The court noted that this decision only applies to discrimination and only comes under Title VII. It did not address any sex-specific restroom or locker room issues, nor did it address religious freedom issues or healthcare issues. So the key point is that sex does encompass sexual orientation and transgender status. So that is now protected from discrimination. Again, the court only addressed termination of employees under Title VII and did not address policies other policies that differentiate on sex, and that being bathrooms, locker rooms, and healthcare issues, as I mentioned. It also did not address religious freedoms under the First Amendment and other religious statutes that protect religious freedoms. We expect that there's going to be an increase in litigation surrounding this decision because we have to address the scope and how far does it extend or how limited is it to this particular type of situation. So what are the takeaways? Again, discrimination is now extends to sexual orientation and transgender status. You must make all employment decisions without any consideration of sex. If you include sex as a basis for your decision, you will have violated Title VII. And you need to now understand that while we don't have a definitive answer right now, some policies and procedures that you have in place that differentiate between sex may be unlawful.
Yeah, and our next case is the Lady Guadalupe case. And before we get into the facts and the meat of that case, it's important to know that it's about the ministerial exception and it's pretty much its expansion, as seen in this recent ruling. Before we get into that, what is the ministerial exception? The ministerial exception comes from the First Amendment, and that protects the religious institutions' right to decide for themselves, free from governmental interference, matters of church government, as well as those of faith and doctrine. And so how does that relate to employment decisions for religious institutions? Essentially, that protects religious or faith-based hiring and firing and can bar employment discrimination claims for religious institutions for certain key employees. And that also, as we see in this case, extends to private religious schools. And so looking at the facts of Lady Guadalupe, we're actually dealing, like our last case, Bostock, multiple cases that are consolidated into one for the Supreme Court opinion. It was two Catholic school teachers who were sued for discrimination. They both taught elementary and taught multiple subjects. Included in those subjects was particularly religion. At issue as well was that both teachers had nearly identical employment agreements that stated the school's mission was to promote and develop the Catholic faith. In addition, it required commitments regarding religious instruction, worship, and personal faith modeling, and also explained to the teachers that their performance would be evaluated on these religious bases. In addition to this employment agreement, they also had a faculty handbook where they had reiterated the same core values of the school and also reiterated the commitments that these teachers make. Again, these teachers taught religion and also attended Mass, prayed, and worshiped with their students. In Lady Guadalupe, the teacher was eventually fired and alleged age discrimination. In St. James, the corresponding case, the teacher was terminated and alleged that she was terminated due to her need for leave to receive cancer treatments. In both cases, the schools stated and argued that the terminations were performance-based. The Ninth Circuit, in both cases, the district court granted summary judgment. The Ninth Circuit reversed Lady Guadalupe on the basis that the teacher at issue did not have a minister title, did not have formal religious training, did not hold herself out as a religious leader. Similarly, in the St. James case, the Ninth Circuit reversed the district court and stated that she lacked credentials, training, and ministerial background. And so the Supreme Court took on this issue head on to discuss exactly how broad is the ministerial exception. In a 7-2 opinion, the Supreme Court reversed the Ninth Circuit and said you had a too rigid application of this exception, and one thing they focused on was the fact that these teachers were not ministers was not dispositive of the issue. They issued this exhaustive opinion where they went through the history of the First Amendment and also the importance of education in various religions. At the end of the day, they determined that the ministerial exception applies to employees who, and I quote, perform vital religious duties. And they also stated in there, what matters at bottom is what an employee does. Simply giving an employee the title of minister is not enough to justify the exception. So again, we're looking at, this is not a rigid application of a rule, but it is the totality of the circumstances. In the dissent, a scathing dissent, Justice Ginsburg said that this has now diminished the rights of all kinds of employees, including coaches, camp counselors, nurses, social workers, in-house lawyers, and any other person who potentially could work for a religious institution. Here, though, again, we were dealing with just strictly teachers, but for Catholic schools, but the focus was not on them actually just being teachers. Again, it went back to, were they performing vital religious duties, and what does that employee do? So the takeaways from this are pretty simple. What can you do to help afford yourself to this ministerial exception and and prevent the government from looking at, if you're a religious institution, making faith-based decisions when hiring and firing employees. First, what you can do, as they did in both cases, would state clearly your religious mission and values in the employment documents. This includes employment contracts or anything that might be disseminated to your employees. In addition, consider providing religious training. Now, in the issue here with Lady Guadalupe, these teachers received informal training and were noted to have limited religious training. Now, there could be such things as retreats or lunch and learns, things like that. We're not talking about necessarily seminary school, but show that your institution, your school, whether or another religious organization, values and puts importance on religious training and your employees being able to exhibit that in what they do daily. The next thing you can do is document your employees' performance with respect to the religious values you hold yourself out to have. And so, like in the case of these two teachers, on a yearly basis, and actually sometimes quarterly, they were reviewed for, are they upholding Catholic missions and values? And this included, did they display crosses, different religious posters in the classroom? Were they consistently praying with their students? So this is very specific to your organization or your business, but if you're a religious institution and you have certain core values and missions, you need to specify what exactly you want your employees to do and how you want them to live, and then hold them accountable to that. The last thing you can do, or to take note of, is that the ministerial exception does not automatically apply to all employment decisions made by religious institutions. Again, it does not matter the title of the employee, although it would help to title them as minister, but you need to look at what they're doing within the realm and scope of their employment, and are they performing a vital religious function. So these are some takeaways that you can apply in your day-to-day workplace if you're a religious institution to help assert a defense against a discrimination claim based upon the ministerial exception.
The next case is Babb versus Wilke. This involves a federal employee, Babb, who worked for the VA as a pharmacist for many, many years. She was over the age of 40, and during the course of her employment, she alleged that there were discriminatory reasons that were made based on her gender and age. She also alleged an unlawful retaliation claim. The lower courts dismissed the gender discrimination claim and the retaliation claim, and all that was at issue at the Supreme Court was the age discrimination claim. For those that don't know, the ADEA, which is the Age Discrimination and Employment Act, protects individuals who are over the age of 40 from age discrimination. Now, there's two separate provisions for federal employees and private employers. The provision applicable to federal employees states that employees who are at least the age of, or applicants who are at least the age of 40 any decision shall be made free from any discrimination at all based on age. The provision applicable to private employers says employers are prohibited from discriminating against any individual because of age. So because of the two separate provisions, the court went through the analysis of what causation test applies to each provision. Because it was a federal employee, the court discussed at length the causation for the federal provision. It took the position, the government took the position that it should have had the heightened burden of proof, which is the but-for causation test, which says that if you remove age as a consideration and the decision would have been the same, then there's no liability. Babb, the employee, took the position that no, it's a lower standard, and if age is a determination at all or a consideration at all in the decision-making process, regardless of whether it affects the outcome, then it's a violation of the ADEA. The Supreme Court agreed with the employee and applied the lesser standard to the federal provision, meaning if age was a consideration at all in the decision-making process, the government would have violated the ADEA. The court again gave an example of how this would work between the private and the federal provisions. So what the court said was if you have non-discriminatory factors that are considered when you're evaluating employees for a promotion, and you have a age consideration component in there, and let's just say you have a 35-year-old employee who scores a 90 on the non-discriminatory factors, and you have a 50-year-old employee who scores 85. And then that 50-year-old employee is docked an additional 5 points, making the 35-year-old at 90 points and the 50-year-old at 80 points. Obviously, regardless of whether the age component was in there, the 35-year-old would have received the promotion because she or he had higher points, whether it be 80, whether the 50-year-old have 85 or 80, the 35-year-old would have gotten the promotion. What the court said is, even in that scenario, the government violated the ADEA because age was a component in that decision-making process. If it would have been removed and the employee would have had an 85 score, it doesn't affect the outcome. The younger employee would have still received the promotion. Even with that analysis, the court determined that the government violated the ADEA. A private employer in that scenario would not have violated the ADEA because it would not have impacted the outcome of the decision. And so that's the distinction between the two provisions. Interestingly enough, however, the court said that in the scenario I just explained, the employee would be limited in the remedies it could recover. The only way the employee in that situation could recover monetary amounts, meaning compensatory damages, back pay, or reinstatement, or any other type of relief, would be that that employee would have to show that the decision would have, the outcome would have been different if the age component would have been removed. So let's say, for example, in the scenario I just gave, if the 50-year-old would have had a score of 92 and the 35-year-old would have had a score of 90, but the 50-year-old was docked the 5 points, then that employee would have not been given the promotion. But if age was not a consideration and that employee was left with a score of 92, he or she would have been given the promotion. So in that scenario, the employee would have received monetary damages. So at the end of the day, while it's a more lenient standard for federal employees, in order to get any type of monetary relief, you still have to show that the decision would have been different if age wouldn't have been a consideration. So here are the takeaways. Again, employment decisions must be made without any consideration of age. The federal government is actually, in this instant, held to a higher standard than private employers, which is a little bit unusual. And the decision, again, does not extend to private employers, and this includes state and local governments. State and local, even if you're public, state and local government employees are held to the same standard as private employers.
And our last case is the Intel Corp versus Sulyma case. And this deals with actual knowledge and the time that a planned beneficiary must file suit under ERISA for a breach of that fiduciary obligation. Before we get into the facts, it's good to know that generally, if you offer a plan through your business, that planned beneficiaries or employees generally have 6 years from the breach of fiduciary duty to file suit. But if they have actual knowledge of a breach, they have 3 years from when they acquire that actual knowledge to file suit. There's also another timeline where if in cases of fraud and intentional concealment, there's 6 years from when they uncover the fraud. But here we're going to be focusing on the 3 years from actual knowledge. And in a 9-0 opinion, the Supreme Court held and also defined actual knowledge, and in doing so said, disclosure alone is not enough to prove actual knowledge. No actual knowledge when a plaintiff does not read or recall reading disclosures, and also actual knowledge is in fact a requirement that the plaintiff become aware of the information. And so the facts of this case go back to the 2010 to 2012 when Sulyma, who was employed by Intel Corp, had a retirement plan and a 401k with them. After the 2008 recession, Intel Corp's investment committee decided to shift their investments from primarily in the stock market to diversify and get alternative investments. And when I say alternative investments, I mean private equity, hedge funds, and commodities, and things of that nature. After leaving Intel Corp in 2012, Sulyma began to notice that his investment was lagging behind the market and complained that the Intel Corp had overinvested in these alternative investments. The hedge fund fees, for example, were excessive compared to what they should have been paying. And based upon that Intel Corp had breached its fiduciary duty to him in managing and investing his funds. In response, Intel Corp argued that the suit was untimely because he filed it more than 3 years after him having actual knowledge of the alleged breach. And in support of this argument, they argued that he received numerous disclosures of the years, largely through email and a few by mail. But the emails he was receiving were these investment plan notices that in the notices said, hey, look, this is the plan information generally, in a very broad sense. If you want more information, go to this benefits website. They also sent via email their general plan descriptions and pointed back to the online source saying, hey, if you need more information, go to this website. In addition, they sent annual disclosures that included return rates and also, again, said go to this website for more information. At the end of this, they produced evidence that showed that Sulyma had in fact viewed this website that contained all this more detailed information dozens of times and, as the court described it, on a repeated basis. Despite this evidence, Sulyma testified in his deposition that, one, he was generally unaware of how his money was invested at Intel Corp. Two, he said he did notice the emails, but that it did not provide the specifics on the alternative investments, so he was generally unaware of what that meant or included. And then most importantly, what the court focused on is that he testified that he did not remember reviewing disclosures. And this was in light of the evidence showing that he had visited this website dozens and, again, repeated times. The district court granted Intel Corp's summary judgment saying his claim was in fact time barred because he did have actual knowledge when he visited these websites. The Ninth Circuit then came in and said in light of his testimony that he did not recall that there was a fact issue as to whether or not he had actual knowledge. So the Supreme Court picked up this very narrow issue and said, hey, this is the time for us to really define, because it did not have an actual definition in ERISA, what was actual knowledge in the context of the statutory scheme. And what they did was they looked at the plain meaning and went to look at Merriam-Webster and said, look, this is not defined because it doesn't need to be defined. They distinguished that actual knowledge is, again, actual knowledge. It is not you should have known, it's you actually knew. And so based upon this and looking at the facts and how Mr. Sulyma testified, they held that ERISA requires more evidence than disclosure alone. And I repeat that's important, that disclosure alone is not sufficient to avail yourself to this 3-year statute of limitations. And in holding so, the justices normalized themselves in the context of the case and said, look, some of them even said, look, we get these disclosures for our plans yearly as well, and admittedly, we don't even read them. So how can we hold the everyday employees, which I think under ERISA it affects 130,000 people across 130 million people across the U.S. How can we hold them to the standard when we, in fact, ourselves don't have actual knowledge of our plans? They said, though, that this is not to say that you can't prove actual knowledge through circumstantial evidence or argue that the employee had willful blindness and not knowing what was in the plan, but they were looking at the discrete facts of the case and weighing the testimony of Mr. Sulyma versus the evidence that Intel Corp had used. And so what is the takeaway from all of this? And again, you cannot stress enough that really the rule is here that disclosure alone is not enough. It's not sufficient for you to establish actual knowledge by saying, hey, I sent this mailing every year, or I sent them to this website and they opened it and clicked on it. You have to prove other evidence to show actual knowledge. And when looking at this, the Supreme Court noted that actual knowledge is a lay term, so you need to look at this in the ordinary meaning. And so how can you do that? What can you do? They really didn't define what exactly you needed to do. They just said you need to do more than disclose. And recently, the Department of Labor issued a final rule for electronic safe harbor disclosure rules with respect to ERISA, and said that employers and plan fiduciaries establish or satisfy their duty to disclose certain information if they issue it electronically or via website. And I note this because this is a good opportunity and tool for employers to start utilizing this technology, because it gives you more functions than merely mailing it to your employee, to where you're not stuck in a situation like Intel Corp, where Intel Corp argues, like, look, the guy had actual knowledge. He was constantly looking at the information. I know he testified this, but the documentary evidence says otherwise. Again, that wasn't enough. And so what exactly should you do? you should track when the disclosures are viewed and opened. And so how is this different than what Mr. Sulyma did? So if you have electronic disclosures, you can have functions similar to email read receipt or some type of confirmation, almost as you're reading terms and conditions at the end, saying when you click on it, you have to check a button, press OK, and also you can track views at a certain website. The issue in the Sulyma case was not that that he clicked on certain documents, is that all they had was that he went to certain websites generally, and they weren't exactly sure what information he was looking at. So if you look at the disclosures that has the detailed information, that contains the information to show, hey, this is exactly how the plan is invested, you should put certain things in place that can monitor when somebody clicks on those specific documents with that information. General reference to the information is not enough, as we can see in the case. And further into that, you should keep records of if somebody asks you, hey, I have a question, how's my money being invested? Or hey, how can I object to something, or how can I change my investment, or how's it generally doing? You should monitor those questions, and if you receive an email about that, throw it into their file. And included in questions is the request for additional information. And last, we mentioned the acknowledgement forms, but similar to when you issue other employment documents, have your employees, whether by hand or via email, fill out something that gives them a duty to say, hey, I affirmatively did X, Y, Z. Now, again, these can look a lot of different ways, and it really is up for you to find something that tailors your needs best. But again, disclosure is not enough for you to avail yourself to this 3-year period. And that's what's most important, as seen in the Sulyma opinion.
So now we're going to take some question and answers that were received throughout the presentation. The first one I'll go ahead and take. What, if anything, should employers be doing in light of the Bostock decision? So what you all should be doing is looking at your handbooks, updating your handbooks to include gender identity and sexual orientation as a now protected characteristic. You should also be looking, training your supervisors and HR to make sure that they are aware now of this additional protection for these certain employees, and make sure that they're aware that they cannot make decisions based on somebody's gender identity or sexual orientation. Again, this is all new this past summer, and so some people may not be aware of this decision, but it impacts anyone covered by Title VII. The other thing you need to start thinking about is looking at gender-specific policies, whether it be your dress code. Obviously there are certain dress codes for women. Most companies have certain dress codes for women and men. Those may need to be modified to the extent somebody who was born as a male but has now identifies as a female. There may be exceptions that need to be made. Another big issue is that every employee needs to understand that they should not, similar to racial jokes, sexual jokes, any slurs that are made, the employees need to understand that none of this is going to be tolerated, whether it's race, sex, or now jokes or slurs about somebody's sexual orientation and gender identity. So those are some of the things that you all need to start thinking about right now, if you have not already.
It looks like we have another question, and I think it goes to Sulyma, so I'll take that. It says, am I covered on actual knowledge if I issue electronic disclosures with an acknowledgement? First, that's not necessarily a loaded question, but I should address something in there. So when it says, am I covered? What we're talking about here, what Sulyma addresses, there's not a requirement for you to give actual knowledge to your plan beneficiaries. Now, ERISA does require you to disclose adequate information, but the covered, quote unquote, is a defense that you can assert with the actual knowledge. So this is not a requirement for you to give actual knowledge, but it is something you should consider doing and providing certain information so you can avail yourself to the certain defense. And why is that important? So why is the 3-year versus 6-year important? So in I guess in a practical sense, if you have an investment dated you make a decision to shift your investments in 2011, and somebody knows of it then and starts to see, I guess, the returns decrease or diminish and the fees go out the door, it's obviously a lot more difficult to make decisions based upon performance in 2014 versus 2017. And the longer the statute of limitations, the more it's open to scrutiny, put simply. So this is why we're telling you should provide more information than you're required to do so that you can give yourself a legal defense if somebody complains of you breaching your fiduciary duty. And so when it says, is it enough to give electronic disclosures with an acknowledgement? The simple answer is no. There's nothing definitively to say that's enough alone. But it's helpful to have the acknowledgement. Again, in the case, the plaintiff testified he didn't remember or recall reading them, despite all the evidence suggesting otherwise. And the court noted that, look, because of this testimony, we can't say he had actual knowledge because he said he wasn't aware of it. But they also noted that plaintiffs are under duty to testify truthfully, and so if you also produce, if you can controvert that to a certain degree, then and show willful blindness, then you can show actual knowledge. So this acknowledgement is the more evidence, is an example of something you could do in addition to the disclosures. Now, in certain instances, it may be sufficient. It kind of depends on a case-by-case scenario. But again, it's more just emphasizing that disclosure alone is not enough for you to avail yourself to this 3-year time limitation.
Hunter, would it change anything if the acknowledgement said, I have read and understand all of the disclosures?
So that would, again, be helpful in additional evidence, but it's hard to say definitively that alone is sufficient. It is definitely something, if you're going to do an acknowledgement, it needs to state things like that, like I read these disclosures, I understand. And obviously there's a limitation upon that because the justices, as they noted themselves, we're all normal people. We're not financial advisors. We don't really know the ins and outs of things. So the whole I understand thing might be a stretch, but it is helpful to know I understand these are the decisions that are being made. And so again, that would be helpful, and it's something you should include. But is it dispositive? It really depends on the instances. But that does weigh heavily if somebody does sign something that they need to explain, hey, why did you check this box saying you read and understood these documents, but here today you're saying you don't remember recalling them or that you didn't even read them. So there's going to be issues created for a plaintiff if you do have documents indicating that.
All right, and the next question is, what causation standard is used for ADEA claims brought by public employees at the state and local level? I briefly touched on that. Historically, the ADEA only applied to private entities or private employers. It was subsequently revised to include that the federal sector provision, and at the time that revision was made, another revision was also made to bring into other public employees at the state and local level within the private employer definition. And so the more lenient federal standard does not apply to state and local level employees, public employees.
Oh, and I guess we have one more in Sulyma. That must be a popular case. Does Sulyma affect suits brought by the Department of Labor? And as you know, under ERISA, your plan beneficiaries can file for breach of fiduciary duty, but also the DOL can bring its own action. And in short, it doesn't necessarily address specifically suits by the DOL, but it does give us some dicta on how this is affected. In looking at whether or not disclosures alone, they explicitly looked at, look, the DOL receives hundreds of thousands of disclosures each year, and that it would not be reasonable for the DOL to receive your disclosure and for you to impute actual knowledge onto them. And again, this is not really hard and fast rules, although a lot of people think, that, and maybe rightfully so, that the actual knowledge requirement has been heightened by this decision, but they're just differentiating it from constructive knowledge, which is I should have known. And so in looking at this, they look at the reasonableness. It would not be reasonable to say, hey, because I sent my plan documents and the information I'm required to disclose to DOL to them, that does not impute actual knowledge upon them. They don't explicitly go that far to say that, but is in looking at the reasoning and their reference to DOL suits and their reference to themselves as mere mortals, as justices, and the numbers with respect to how many plans and whatnot are disclosed to DOL, it is safe to assume that, again, that this rule of disclosure is not enough for actual knowledge. It's even more so for the DOL.
One last question. What happens if an employee refuses to recognize a transgender employee because of his or her own religious beliefs? This is a little complicated, and I don't think I can actually answer this question. The Supreme Court in Bostock specifically said that that its decision in that case was not an analysis of religious beliefs under the First Amendment or other statutes that do provide protection for religious freedoms. And so I think this question is going to be litigated as part of what transpires as a result of Bostock, because as we all know, we as individuals have First Amendment rights, and our religious freedoms are protected within those rights. And so you basically have two conflicting protections at issue with that type of question. And so I believe there are some cases that are the Supreme Court are going to be dealing with as it relates to freedom, religious freedom protections in this upcoming term. It's not specifically in the employment context, but it may provide guidance of how we handle situations where there's these two conflicting protections at issue.
Yeah, and just in the context of the ministerial exception and what we talked about in the Lady Guadalupe case, one, I mean, as you all know, that these aren't hard and fast black and white rules, and that really is a case-by-case analysis every single time you're making an employment decision. And even more so in this scenario, one, you need to look at the employer, what kind of institution you're working for, what is the core mission and values of your company or institution. Now, Our Lady Guadalupe expanded it from churches, not necessarily expanded it, but they extended it to private religious institutions, private religious schools. And so if you fall within that category where the primary goal for whatever institution you have is a religious organization that's protected by the First Amendment, then that checks the first box. And then the second box is, does this employee perform a vital religious function? And again, that's a case-by-case scenario. And even if you could check both those boxes, it really is no guarantee that this ministerial exception, which is it's not necessarily rare, but it's just not litigated often, for it to be applied. Actually, recently, as of 2 weeks ago or 3 weeks ago, the Northern District of Illinois refused to apply the Supreme Court's analysis of the ministerial exception as broad as they did. Now, the 7-2 opinion obviously holds weight over the District Court Northern District of Illinois, but there will be, especially based upon the dissents, there will be some pushback on this opinion. How broad can we exactly do this? Can you fire, if you're a religious organization and you have a vital religious employee, can you fire them for any reason? The recent district court case says you still need to have a bona fide religious reason for firing them. Again, that kind of gets into what Justice Thomas says, that look, you're encroaching on what the religious institution the decisions and deference they should be afforded as to what qualifies as a religious employee or ministerial employee or a religious-based decision. So it's not, you're stepping into a lot whenever you're going into how should this be applied, but you should know that this ministerial exception is broader than it was traditionally thought of now.
And I think that's all the questions we have.
Yeah, and if anything pops up where you think one of these cases affects your business, feel free to reach out to either of us, or hey, shoot us an email saying, can I get the slides? I think it'd be helpful. We'd love to send that to y'all.
Thank you all, and hopefully next year we'll be face-to-face.